Your client's net worth has 11 digits, your NENDA has no expiration date, and the call you just received at Thram is the kind that makes careers, or ends lives. You're in a rental car in a city you weren't in 12 hours ago. Your suit is from yesterday. The phone in your hand has 4 different numbers saved under the same contact name. Work. You've been awake for 19 hours. The last thing you ate was an airport sandwich in a terminal you couldn't name under oath. You don't have a business card. Business cards create paper trails. Paper trails create problems. Problems are exactly what you were hired to make disappear. Your LinkedIn profile lists you as a strategic consultant. 47 connections. 0 posts. A profile that exists specifically to be found and reveal nothing. The man who pays you is worth more than the GDP of a small nation. He has lawyers, PR firms, security teams, lobbyists, and a board of directors. None of them can handle what you handle, because what you handle is the stuff that cannot be put in writing, cannot be routed through official channels, and absolutely cannot become public. That's why you exist. That's why your rate is what it is. That's why you answered on the second ring. What kind of problem requires this, and what kind of person becomes the solution? Level 1. The intern with discretion. You're a third-year associate at a white shoe law firm. You're excellent. You bill 2,400 hours a year, and you've developed a reputation for exactly one specific thing: you don't talk. Not about cases, not about clients, not at dinner, not after drinks, not to your partner, not even to yourself in the private way that most people process their days. Information enters you and stays there. At 26, you've internalized confidentiality so completely it's become a personality trait. The senior partners have noticed. That's the point of noticing. On a Friday afternoon, one of them calls you into his office. He hands you a manila envelope and an address and says, "Go personally, no courier, make sure it's received by the individual named on the front, then come back." He doesn't tell you what's inside. He doesn't explain the address. He says don't discuss this with anyone, and then he says it again in a different way, to make sure you understand the first time wasn't a pleasantry. You do it. You don't ask what's inside. That, you'll realize later, was your actual interview. The law degree was the prerequisite. The silence was the application. When you return Monday morning, the partner doesn't mention the envelope. No one does. But you notice a file that was heading toward very public litigation has been quietly, completely closed. As though the dispute had simply decided to stop existing. You made something disappear. You don't know what it was. You notice you're not bothered by that. The most dangerous professional skill in the world isn't expertise. It's knowing when not to ask. Level 2. The crisis runner. Your first private client is worth $400 million, which in this world makes him almost modest. His 23-year-old son has been involved in an incident at a ski resort in Verbier. If it reaches the press, the timeline collapses badly. A custody case falls apart in London. An SEC review of his father's fund shifts from routine to pointed. And a prior incident, one that was already handled once, quietly 3 years ago, surfaces as a pattern. You have 48 hours before a journalist who received a tip files his story. You have a phone, a budget that doesn't appear on any ledger, and the complete trust of a man sitting in a chalet waiting for your call. The crisis communications industry, firms like Brunswick, Teneo, Kext CNC, is a documented, legal, multi-billion-dollar business. At the elite private level, you operate outside those structures entirely. No agency. No retainer agreement with a letterhead. Payment arrives through a family office holding company that exists for exactly this kind of flexibility. What you do exists in the space between legal strategy, PR, and direct negotiation, a gray zone no single licensed profession technically covers, which is precisely what makes you valuable. You reach the journalist. The conversation is professional, indirect, and deniable by both parties with complete plausibility. You don't offer money, that's crude, and more importantly, it's prosecutable. You offer access, a better story, an exclusive, later on something larger. He takes it. The original story never files. You're not entirely certain what you just did sits cleanly on the legal side of a line you used to be able to locate precisely. You're completely certain it worked. Nobody broke any laws. That's what you tell yourself. The second time, you stop telling yourself anything. Level 3. The silence architect. You now manage a portfolio of silence. Across your primary client's life, there are 14 signed NDAs. Former employees. Former partners. A journalist who came too close in 2019. A local official in a country your client has never officially visited. You didn't draft them all. You maintain them. Every 6 months, you make a call, arrange a wire transfer, schedule a dinner at a restaurant where the bill goes to an account no accountant reviews directly. Not to threaten, never to threaten. Threats create records, and records create exposure. You do it to remind. You do it to make the silence feel chosen rather than imposed. The hashtag #MeToo era made ENDA architecture visible for the first time. Not the documents themselves, but the machinery behind them. The investigators, the attorneys, the go-betweens. The explicit and implicit pressure on people who signed not entirely of their own free will, in rooms where the power differential was not ambiguous. UK super injunctions, court orders that prohibit reporting on both the allegation and the existence of the injunction, became public knowledge in 2011 when the Supreme Court examined them directly. The law has since evolved. The practice hasn't stopped. It's adapted, which is a different thing. One of the 14 calls you back. She's engaged. Her fiancé has found out not everything, but enough to ask questions she can't answer without opening something she signed an agreement to keep closed. She wants to talk, not to a lawyer, to you. She trusts you in the particular way that people trust someone who holds power over them and has chosen, so far, not to use it. That choice can be revoked. Both of you understand that. The understanding is the mechanism. You listen for 40 minutes. Then you remind her, very gently, of the wire transfer schedule. The conversation ends warmly. It always does. Level 4. The investigator. You retain a firm. You don't meet them in person. That's what intermediaries are for. You send a brief through a channel that leaves no record on either end. A name, a city, a specific problem that requires context before it can be addressed. 2 weeks later, you receive a report in an encrypted folder that will be deleted from their servers at the same moment you download it. The report is thorough in the way that makes you prefer not to think about how it was assembled. It covers financial situation, relationship history, legal exposure, pending disputes, and, most usefully, what the subject wants that they don't yet have, what they need, what they'd trade for it. Firms like Kroll, K2 Integrity, and others operating in private intelligence occupy a documented legal gray zone. The existence of the firms is public. The methodology their operatives use in the field is frequently not legal, which is a distinction the firms themselves maintain carefully in how they structure client relationships. The client asks for information. The firm provides it. The gap between those two sentences is where most of the actual work occurs. You've understood this for some time without examining it directly. The report contains something you didn't request, a detail about a family member of the subject, a sister, a financial situation, a vulnerability that has nothing to do with the problem you engaged the firm to research. It's sitting in a folder on your encrypted drive. You haven't deleted it. You've opened it twice. You tell yourself you'll delete it before the end of the week. Information you didn't ask for is still information. The only question is what you owe the person it belongs to, and whether that question ever actually stops you. Level 5. The Regulator Whisperer. Your client is facing a regulatory inquiry, not a criminal investigation, not yet. But the division chief running it is ambitious and methodical, and the document trail, if followed correctly, terminates somewhere your client cannot afford to go. The revolving door between regulatory bodies and private practice is one of the most documented features of the American and British institutional landscape. Former SEC commissioners join law firms. Former FTC officials become consultants. Former Treasury officials open advisory practices in D.C., where their value is not their public expertise, it's the phone numbers in their contacts that belong to people still inside. This is largely legal. It is widely reported. Academic literature on regulatory capture has documented it for decades. It is not controversial to note that the system produces this outcome. It is only uncomfortable to be the person using it. You make 3 calls over 2 days. None of them are to lawyers of record. One is to a former colleague now at a consultancy with a K Street address. One is to a foundation board member who has known the division chief since graduate school. One is to a former division official now on your retainer, officially categorized as a compliance advisor, whose specific value is knowledge of how this process works from the inside and which decision points can be redirected without leaving visible marks. The inquiry is restructured. The scope narrows. The trail that led somewhere dangerous now terminates at a filing deadline and a fine in the mid-6 figures, the kind that gets paid in a week and reported in paragraph 9 of a story that runs on a Friday afternoon. The division chief transfers to a different assignment 3 months later. You didn't arrange that. You're almost certain you didn't arrange that. You make a deliberate decision not to investigate further. The difference between corruption and access is about $800 an hour and a law degree. You have both. Level 6. The international problem. The problem is in a country whose name you prefer not to say on phone calls. Your client controls a resource license that a government ministry has decided should belong to a competitor, one with better relationships with the current administration, which in this country means something specific and transactional that everyone understands and no one documents. The problem is not legal. The solution isn't either, in the technical sense, but it will be structured so that nothing traceable connects your client to the outcome, and the structure will be built on locally established practice, which provides a layer of distance that the U.S. Foreign Corrupt Practices Act and UK Bribery Act both technically permit under certain readings of facilitation. You fly in on a connecting route. You meet a man in a hotel lobby who introduces himself with a first name that is almost certainly not his first name. He's been recommended through 2 intermediaries, neither of whom you've met in person. The conversation is entirely about process, timelines, documentation transfers, the administrative sequence through which an existing license is reviewed and reissued. The word payment is never spoken. Neither is the word bribe. The conversation could be the conversation of 2 attorneys discussing a procedural timeline if you ignore what both parties understand the timeline to be in service of. Before you leave, the man with one name mentions, conversationally, as an aside, the way someone mentions the weather. What happened to the previous consultant who tried to resolve this same problem without engaging his services? He says it without inflection. You understand it completely, and you understand that he knows you understand it, and that this exchange has accomplished its purpose. You wire the retainer from an account in Luxembourg. On the flight home, you order a whiskey and read the in-flight magazine like a person who spent the week at a conference. Level 7. The personal architect. You've stopped counting the things you know. You know about the offshore medical treatment your client received 3 years ago for a condition that, if disclosed publicly, would collapse the public persona he's spent 40 years constructing. You know about the child who exists in a city on another continent, whose existence is managed through a separate trust you help structure with attorneys who were chosen specifically because they operate across jurisdictions in ways that limit what any single one of them can see. You know about the property held through a layered ownership chain so complex that even the lawyers who built it can no longer see to the top from where they sit. You know all of this, not because you were told, but because you were present when each of these things was created. Family offices managing ultra-high net worth principals, the entities that handle everything from investment management to special situations, are documented structures employed by the wealthiest individuals globally. The staffs run to dozens or hundreds of people. The special situations function, which appears in wealth management literature without much elaboration, is where you exist. Former personal advisors who've written about these relationships describe a transition point where the professional dynamic shifts, where you know more about the principal than their lawyers, their family, or their closest friends, where that knowledge is simultaneously what makes you indispensable and what makes leaving impossible. Your client asks you to handle something involving his eldest son. You've handled things involving his eldest son before, once at a university, once in a European city, once involving a vehicle and a jurisdiction with relaxed reporting norms. This one is different in a specific way that you identify the moment he finishes describing it. The person on the other side is 19 years old. She's frightened. She has no advisor, no attorney, no institutional framework, and no understanding of what she's about to be asked to sign or how it will follow her. You've told yourself for years that there's a line you won't cross. You're standing at it now. The surprise is not that it's here. The surprise is how far you traveled before you arrived. Level 8. The exit problem. You want to leave. You've wanted to leave for 2 years. You have a number, a specific figure, an amount at which you told yourself you would stop, the threshold at which the money would be enough to make the rest of it worth absorbing. You passed that number 18 months ago. You have not stopped. The problem is no longer the money, and it hasn't been for some time. The problem is that leaving requires a kind of permission that doesn't exist in any contract but exists everywhere else, in what you know, in what you've structured, in the chain of decisions you participated in across a decade that can be read, from the outside, in ways that are not flattering to you. Michael Cohen, who served as personal attorney and self-described fixer for a powerful principal before a very public separation, documented in detail what the disintegration of that relationship looks like from the inside. The psychological dependency, the escalating rationalizations, the way that total proximity to power creates a worldview in which the principal's interests and your own become indistinguishable until the moment they separate violently. You drafted 3 of those litigation strategies for your client. You know exactly how they work. A federal investigator makes contact, not officially, not with a subpoena or a case number, just a conversation in the lobby of a hotel you frequent, framed as a coincidence that both parties understand is not a coincidence. He speaks carefully in the language of these conversations about the warmth with which cooperation is typically received and about how your current exposure, viewed from a certain angle, is considerable. He is accurate on both points. You have 72 hours to decide. You ask for 96. He gives you 48. You sit in your car in the hotel parking structure. You've been in this position before. Not this exact position, but positions of this shape. Problems with a fixed window and high consequences and no clean resolution. You've solved all of them for someone else. You understand, sitting in this parking structure, that this was always the structure. That every problem you dissolved transferred a portion of its weight to you. That a fixer is not someone who makes problems disappear. A fixer is someone who absorbs them. And you have been absorbing for 11 years without noticing the accumulation. The fixer's greatest professional achievement and greatest personal failure is that he made himself impossible to replace and impossible to release. Somewhere tonight, a senior partner is calling a third-year associate into his office. It's Friday afternoon. The building is emptying. The associate is excellent, ambitious, precise, constitutionally discreet in the way that people like this are born with and institutions then select for. The partner has been watching him for 18 months, waiting for a problem that needed exactly this kind of person. He hands over a manila envelope, an address. He says, "Go personally, no courier, come back when it's done." The associate takes the envelope. He doesn't look inside. He doesn't ask what's in it, who it's for, or why it can't go through normal channels. He understands, correctly, that the not asking is the qualification. He walks out. The partner watches him go. And for a moment, just a moment, brief enough that he doesn't have to examine it, the partner remembers a Friday afternoon from 20 years ago. A different office. The same envelope. The same address, roughly. The same instruction. He remembers how it felt to be trusted with something he wasn't told the contents of. He doesn't think about what the associate will know in 20 years. He closes the folder on his desk. He turns off the office light. The system doesn't need people who understand what they're entering. It needs people who don't ask until they're too far in for the answer to change anything. That supply has never run out. It is running right now.